Good morning, everyone. Bonjour tout le monde. My name is Vanessa McDonnell, and I am the co-director of the U Ottawa Public Law Center. And today we're thrilled to host this fireside chat on Jan Campagnolo's new book, which I have here, Behind Closed Doors, The Law and Politics of Cabinet Secrecy. I'd like to begin by saying that Jan and I are joining you today from the traditional territory of the Algonquin people. I acknowledge their longstanding relationship to this land and their continued guardianship of it. Notre présentation aujourd'hui sera bilingue et nous avons aussi la traduction simultanée disponible. There is simultaneous translation available today since our presentation will be bilingual. If you look on the bottom of your Zoom screen, you should see an interpretation button. If you press that, that will allow you to hear the presentation in the language of your choice. Juste en bas de l'écran, si vous cherchez la traduction simultanée, il y a un petit bouton en bas qui dit interprétation. Et là, ça va vous donner le choix de langue pour la présentation. Alors, je vais commencer en introduisant ma collègue Jan. Jan est un professeur agrégé à la faculté de droit de l'Université d'Ottawa. Il est aussi membre de l'exécutif du Centre de droit public. Jan est aussi membre du barreau de l'Ontario et avant de devenir professeur de droit, a travaillé comme avocat pendant plusieurs années au bureau du conseil privé. So, we'll jump in here in a minute. I do just want to say a few things about the contribution that I think Jan's book makes to the scholarship in Canada. As someone who studies constitutional law and studies the executive in particular, I have some quick reflections on that. I'll also just let you know that what we'll do today is Jan and I will speak for about 30 to 40 minutes. After that, you're invited to ask questions and we'll take some questions from the audience. Et je vous invite de mettre vos questions dans la boîte Q&A dès le début. Comme ça va nous donner la chance de nous préparer un petit peu, mais il va y avoir une période de questions à la fin. So Jan is Canada's leading authority on cabinet secrecy in Canada. He has been thinking and writing about the topic of cabinet secrecy for a decade, culminating in this book. And Jan's book, as we'll discuss today, examines the rationales behind cabinet secrecy and considers the rules that have developed to regulate the disclosure of cabinet secrets in litigation. Along the way, and making the arguments he makes about whether that regime has struck the right balance, Jan also gives us a peek into the cabinet room by giving us information about how cabinet decision-making unfolds. And I told Jan when we were preparing for this session that that's one of my favorite parts of the book. I think, so many of us are still trying to figure out exactly what it is that goes on inside the executive. And so Jan, in the course of unfolding his arguments, also gives us this sense of how decisions are made within the executive, as well as, some thoughts on the relationship between cabinet, the broader executive, but then also the other branches of state. And so there is an important sort of separation of powers component to the arguments that Jan makes. Alors, I'm not going to say any more. This is supposed to be a discussion, but I congratulate Jan on this book, and I encourage you to all pick it up and read it. Alors, Jan, j'aimerais commencer en vous demandant ce qui vous a amené à écrire ce livre.
Alors, bonjour Vanessa. Moi, j'aimerais commencer d'abord en vous remerciant et en remerciant le Centre de droit public de m'avoir invité pour parler de mon nouveau livre. Et merci aussi pour vos commentaires très positifs sur le livre. Alors, pour répondre plus directement à la question, en 2008, j'ai commencé à travailler au bureau du conseil privé, qui, en plus d'être le ministère du Premier ministre, est le secrétariat du cabinet. Et au jour le jour, comme vous pouvez l'imaginer, plusieurs personnes tentent d'avoir accès aux documents du cabinet, que ce soit dans le cadre de litiges, de commissions d'enquête, de travaux parlementaires ou même en vertu de la loi sur l'accès à l'information. Et ces demandes d'accès sont gérées par le Bureau du Conseil privé en collaboration avec le ministère de la Justice. Alors, c'est dans ce contexte que j'ai été initié pour la première fois au secret ministériel. Étant moi-même passionné de politique et de droit public, le sujet a piqué ma curiosité. Mais j'ai vite constaté qu'il y avait peu d'ouvrages qui avaient été écrits sur le sujet et que peu de personnes, même dans la fonction publique, étaient familières véritablement avec les règles applicables. Alors, j'ai pris l'initiative de préparer une formation sur le secret ministériel pour tenter de démystifier le concept et pour le rendre aussi plus accessible. Et par la suite, après avoir donné la formation à quelques reprises, j'ai eu envie d'approfondir ma réflexion en rédigeant un ouvrage plus complet sur le sujet. Par contre, c'est important pour moi que l'ouvrage soit le fruit d'une recherche et d'une réflexion indépendante. Je ne voulais pas simplement présenter la position du gouvernement, mais je voulais aussi l'analyser de manière critique. Et c'est pour ça que j'ai proposé de faire ce projet dans un contexte universitaire. Ma proposition a été acceptée et je suis infiniment reconnaissant au Bureau du Conseil privé pour m'avoir donné l'appui et la flexibilité dont j'avais besoin pour entreprendre les travaux qui ont, en bout de ligne, mené à la rédaction et à la publication du livre.
Merci, Yann. I think this is always, the first question that people have when they're looking at a new book is, how is it that you came to this topic? What was it in it that you, what was the potential that you saw in it? So now I think let's get into it a little bit. And I know that several of the people who are on this call today know a lot about the inner workings of cabinet and cabinet secrecy. But for those who might be less familiar, can you just tell us a little bit about what cabinet secrecy is and what function it performs in our system of government?
Yes, of course. So to understand the importance of cabinet secrecy, we must understand how the system of responsible government works, especially the confidence and the solidarity conventions. As you know, under the confidence convention, ministers must maintain the support of the House of Commons to remain in power. And under the solidarity convention, ministers are collectively responsible for government decisions, meaning that they stand or fall as a group. For these conventions to work as intended, ministers need a forum to propose, debate, and decide government policy and action. And that forum is cabinet. And cabinet meetings take place in private to enable ministers to speak freely on proposed policies, to reconcile any difference of opinion they may have, and to reach a consensus on what to do. Cabinet secrecy also increases the efficiency of the decision-making process by protecting ministers from undue external pressure and interference. In the end, because of cabinet secrecy, when a decision is made and announced, all ministers can publicly support that decision, knowing that any disagreement between them will remain private and won't be exploited by their political opponents. So in short, without cabinet secrecy, ministers would be unable to remain united in public and would be unable to maintain the confidence of the House. And therefore, the system of responsible government would be dysfunctional.
Okay, so I think, Jan, what you're establishing here is that the stakes are pretty significant when it comes to cabinet secrecy, that there are important values that it protects, that it allows our system to function properly. In a couple of moments, we're going to get to, I think, what are some challenging second order questions about cabinet secrecy, right? Which is what happens when cabinet secrets might be relevant in the context of ongoing litigation. And in that context, how do we balance the need to preserve cabinet secrecy with the demands of litigation, which sometimes also prevent a compelling reason for disclosure? Okay, so we've talked about secrecy. Peut-être qu'on pourrait aussi parler un petit peu de la Convention sur l'accès. Comment est-ce que s'est-elle développée?
Alors, tout comme il faut protéger la confidentialité des délibérations du cabinet, il faut aussi protéger la confidentialité des documents du cabinet. Le système de documents du cabinet que l'on connaît aujourd'hui, avec ses mémoires, ses ordres du jour, ses procès-verbaux et ses décisions, est relativement récent dans l'histoire canadienne. Avant le début de la Deuxième Guerre mondiale, le Canada n'avait ni secrétariat du cabinet, ni système organisé de documents du cabinet. C'est le premier ministre Mackenzie King qui a, avec certaines réticences, créé le secrétariat pour améliorer l'efficacité du processus décisionnel. Ceci dit, le fait de mettre en place un système formel de documents du cabinet risquait de miner la confidentialité des délibérations. Il pourrait y avoir, bien entendu, des fuites, mais il y avait aussi un risque que les opposants politiques des ministres puissent avoir accès aux documents à la suite d'un changement de gouvernement. Alors, la Convention sur l'accès a été développée précisément pour répondre à ce problème. Selon cette convention, donc, les documents du cabinet peuvent seulement être examinés par les ministres qui étaient en poste lorsque les documents ont été créés. Ça veut dire qu'à la suite d'un changement de gouvernement, le gouvernement entrant ne peut pas avoir accès aux documents du cabinet du gouvernement sortant. Et c'est le rôle du greffier du conseil privé, comme secrétaire du cabinet et gardien de ses confidences, de faire respecter la Convention. Et cette Convention-là est importante puisque si la confidentialité des documents du cabinet n'était pas protégée, les gouvernements cesseraient sans doute de les créer et une partie de nos archives serait à tout jamais perdue.
Thank you, Jan. So let's talk a little bit then about what happens when the need for cabinet secrecy runs up against what might be seen as a competing need for the disclosure of cabinet secrets in the context of litigation. And in your book, Jan, you both refer to the common law regime that exists in the provinces, and then you spend quite a bit more time looking at the federal statutory regime, and as we'll discuss, you have some criticisms of that regime. But I think a good place for us to start is actually with that common law regime. So can you tell us a little bit about how historically judges dealt with issues pertaining to the disclosure of cabinet secrets in litigation as a matter of common law?
Yes. At common law, the disclosure of government documents in court is governed by the doctrine of public interest immunity, or crown privilege. And under this doctrine, government documents must be protected if their disclosure would injure the public interest. Historically, a key issue at common law has been who should decide whether the disclosure would injure the public interest or not. Should it be the responsible minister or the judge presiding over the proceedings? During the Second World War, in a case involving the disclosure of the plans of a top secret submarine, the Duncan case, the House of Lords ruled that the minister was the final decision maker. That decision meant that if the responsible minister objected to the disclosure of government documents in litigation, the judge had to accept the objection without inspecting the documents and assessing the public interest. But of course, this rule led to abuses of power. Ministers often objected to disclosure not to protect the public interest, but rather to deprive the other side of crucial evidence in cases against the government. In the Duncan case, the House of Lords had surrendered a core judicial function to the government, namely the power to control the admissibility of evidence in litigation. And this decision was especially troubling given that the government often had an interest in the outcome of the proceedings. Fortunately, by the end of the 1960s, the House of Lords realized the problem and changed its position in Conway and Rimmer. And since then, judges, not ministers, decide whether government documents should be disclosed or not in litigation. In the book, I argue that this position is more consistent with the rule of law and the separation of powers.
So Jan, I think, something that we see here in this context, this question of, who gets to decide whether these documents should be disclosed reflects a tension that we see in the context of a lot of contemporary public law questions, where on the one hand, we want political actors to understand that they have constitutional functions that they're required to fulfill, but we also see the important role that courts play in providing oversight when it comes to the exercise of some of these functions. So in reading your book, I think you're making a specific point in the context of a particular, you're looking at the common law and of course the statutory regime and saying, you think the balance favors having courts decide, but I think there is, this reflects a much broader debate that we tend to have about who decides, who gets to decide, finally. Alors peut-être qu'on pourrait parler maintenant un petit peu de la régime législatif qui existe au niveau fédéral. Peut-être que tu pourrais juste commencer en expliquant très brièvement ce régime législatif et de nous parler un petit peu de pourquoi le Parlement a établi une immunité absolue pour les confidences du cabinet à l'ordre fédéral, écartant ainsi la common law.
Merci beaucoup, Vanessa. Alors, en 1970, quelques années après la décision de la Chambre des Lords dans l'arrêt Conway, et dans le contexte de la crise d'octobre au Canada, le gouvernement de Pierre Elliott Trudeau a établi une immunité absolue pour certains types de documents gouvernementaux, dont ceux relatifs à la sécurité nationale et ceux qui contenaient des confidences du cabinet. Et le but de la disposition pertinente, l'article 41, paragraphe 2 de la loi sur la Cour fédérale, était justement d'écarter la common law pour faire en sorte que ce soit les ministres et non les juges qui décident de la divulgation de certains documents jugés particulièrement sensibles. Vers le milieu des années 70 au Canada, plusieurs groupes, dont l'Association du barreau canadien, ont mis de la pression pour que le gouvernement Trudeau libéralise l'accès à l'information gouvernementale. Malheureusement, sans succès, jusqu'au début des années 1980, quand les libéraux sont revenus au pouvoir, là, ils semblaient enfin être prêts à moderniser le droit législatif fédéral. Et à ce moment, ils ont déposé un projet de loi qui visait notamment à abolir l'article 41, paragraphe 2 et à établir un régime d'accès à l'information. Par contre, à la toute dernière minute, alors que le projet de loi était à l'étude en Chambre, le premier ministre Trudeau a imposé un amendement. Pourquoi? Pour préserver une immunité absolue pour les confidences du cabinet dans le cadre de litiges et pour exclure les documents du cabinet de la portée de la loi sur l'accès à l'information. Et cet amendement a donné naissance aux dispositions que l'on connaît aujourd'hui, c'est-à-dire les articles 39 de la loi sur la preuve au Canada et l'article 69 de la Loi sur l'accès à l'information. La décision de Trudeau était paradoxale en ce sens que le premier ministre faisait suffisamment confiance aux juges pour leur permettre de décider de la divulgation de tous les types de documents gouvernementaux, incluant ceux relatifs à la sécurité nationale, mais pas suffisamment confiance, semble-t-il, pour leur permettre de décider de la divulgation des confidences du cabinet.
So what we see here is a federal statutory regime that leans very heavily against the disclosure of cabinet confidences in litigation. And I think it's fair to say that the spirit of that law exists in some tension with the traditional position of common law. In your book, you are pretty critical of the federal scheme. And so, I mean, I think this really takes us to the heart of the book, which is your criticism of the existing scheme for the disclosure of cabinet confidences. And I hope that you'll indulge us and share some of those critiques with us and what the sort of the basis for those critiques is.
Yes, of course. Well, in short, I see two main problems with Section 39 and Section 69. First, these provisions are too broad, in my view. And second, they're not subject to meaningful judicial review. So the first problem comes from the fact that these provisions don't provide a substantive definition of the term cabinet confidences. Instead, they provide a list of documents in which cabinet confidences can be found. But the list is not exhaustive. These provisions can therefore be used to protect any document, even emails between public servants, that contain information loosely connected to the collective decision-making process. For example, in 2018-2019, 76% of the documents excluded based on Section 69 were not official cabinet documents. So, in short, whether a document is excluded under the access regime depends entirely on whether it reveals cabinet confidences. It doesn't depend on whether its disclosure would truly be injurious to the public interest or whether the public interest truly requires that it remain confidential. So that's the first problem. The second problem is, in my view, even more serious. In litigation, judges don't have the power to inspect the documents certified by the clerk to confirm that Section 39 is properly applied. And the same is true under the Access to Information Act. The Information Commissioner and the federal court cannot inspect the documents excluded under Section 69. Because of these problems in the book, I take the position that Section 39 and Section 69 create a form of legal black hole that could be used to conceal unlawful conduct.
So to summarize then, you're saying sort of two main things. One is that the scope of disclosure is too limited, or to put it differently, the scope of protection of cabinet confidences is too high, that it sweeps in documents that could and should be disclosed in the context of litigation. And second, that the judicial role is insufficient here to ensure that that the documents that should be disclosed are actually disclosed. I don't want to get too technical here, but there is this piece of in your book where, I would like to take you there, I guess. Là, je parle des documents de travail. Et je sais que c'est un petit peu technique, mais est-ce que tu pourrais nous parler des documents de travail? Qu'est-ce qui est-il arrivé à ces documents? Et pourquoi vous nous en parlez?
Bien sûr. Donc, les documents de travail, ou en anglais, les discussion papers, était un type de document du cabinet qui avait pour but de lancer une réflexion sur un sujet d'intérêt public. Alors, les documents de travail contenaient des renseignements purement factuels et contextuels qui visaient à aider les ministres à comprendre un problème et identifiaient aussi les options possibles pour régler le problème. Mais les documents de travail ne contenaient aucune recommandation. Alors, lors de l'adoption des articles 39 et 69, le Parlement avait prévu une exception particulière pour les documents de travail. Au lieu d'être protégés pendant 20 ans, comme les autres documents du cabinet, les documents de travail devenaient accessibles dès que le gouvernement rendait publique sa décision sur le problème abordé dans le document de travail. Et donc, les documents de travail devaient promouvoir la transparence gouvernementale et ouvrir une fenêtre sur les travaux du cabinet en communiquant aux citoyens les faits sur lesquels les ministres s'étaient fondés pour prendre une décision. Malheureusement, en 1984, le gouvernement a arrêté de produire les documents de travail et a transféré les renseignements de nature factuelle et contextuelle qui se trouvaient dans les documents de travail dans la section analyse des mémoires au cabinet. Ce changement a eu pour effet de neutraliser l'exception relative aux documents de travail puisque les mémoires au cabinet sont protégées pendant 20 ans. Alors, il a fallu attendre près de 2 décennies pour que cette décision du gouvernement soit contestée avec succès. En 2003, dans l'arrêt Ettle, la Cour d'appel fédérale a pris note des changements apportés au format des documents du cabinet par le gouvernement et, malgré l'objection du gouvernement, a décidé que l'exception relative aux documents de travail demeurait pertinente et devait désormais s'appliquer à la section analyse des mémoires au cabinet. Par contre, autre revirement, en 2012, le gouvernement de Stephen Harper a décidé d'abolir la section analyse des mémoires au cabinet. Et donc, ce changement a fait en sorte qu'il est devenu maintenant très, très difficile d'appliquer l'exception relative aux documents de travail. Alors, la question des documents de travail est importante parce qu'elle constitue un exemple de situation où l'interprétation et l'application des articles 39 et 69 par le gouvernement peut être jugée inappropriée.
Merci Yann. Et oui, jusqu'à maintenant, on n'a pas vraiment parlé à l'accès à l'information, mais c'est un aspect très important de ton travail aussi. And so I'm glad that you're raising this and the kind of challenges that exist for ordinary citizens in trying to figure out how decisions are made within government. And again, trying to walk that fine line where on the one hand, cabinet secrets are kept confidential so that cabinet can deliberate freely and fully. But then that documents that exist at some remove from that core decision-making process remain accessible to Canadians so that they have an understanding of how it is, the factual and informational basis upon which decisions are made and how government is being advised. So I think the access to information regime is very much a part of this. Okay, so you don't just throw your critiques out there and leave them hanging in the book. You make a number of recommendations about how the federal statutory framework could be revised, reformed to address the concerns that you raise in the book. So can you tell us a little bit about those recommendations for reform? And I'll just say that I'm now getting to the end of my questions, and I have more questions I could ask, but I also want to remind the audience that I'd be pleased to take questions from the audience as well and put those to Jan today. So, give that some thought while Jan is responding. Jan, est-ce que tu pourrais nous parler un petit peu de les modifications que toi tu suggères au régime législatif fédéral?
Yes, of course. So in the book, I put forth several recommendations to ensure that the scope of cabinet immunity is proportional to its objective, and to ensure that cabinet immunity claims are subject to meaningful judicial review. So if I focus on the four main recommendations, number one is that cabinet immunity should, in my view, be protected based on an injury test, as opposed to a class test, as is currently the case. So the question should be whether disclosure of the information would be injurious, not whether the information is or is not a cabinet confidence. Second, cabinet immunity should not be claimed when the public interest in disclosure outweighs the public interest in non-disclosure. So even if disclosure might be injurious in a given case, sometimes the public interest will require it. For example, to prevent serious health or safety hazards to the public, or to shed light on serious allegations of fraud or mismanagement, as we've seen recently in the context of the SNC-Lavalin controversy. Third, I think cabinet immunity should not be claimed to protect factual and background information related to a decision that has been made public. In other words, there must be a true exception for discussion papers. And finally, courts should have the power to inspect cabinet confidences to ensure that Section 39 and Section 69 are properly applied by the government. And this recommendation, in my view, is the most important. I think we could tolerate an overbroad immunity, provided that its application is subject to meaningful judicial review.
Okay, just making some notes here, because your reform suggestions are very interesting and I think are very rich in terms of the potential for discussion. So I'm seeing a couple of questions here coming in, and I'm going to take a look at them, but I am going to fire off, one more question of my own, and that is around the reforms that go to the scope of judicial review. And, because I think this is one that I really struggle with. I think it's clear that judicial oversight plays an important role. At the same time, I do think there is something about, making these assessments about whether cabinet confidences should be disclosed in the context of litigation that really goes to the core of the executive's functions. So I think the kind of tension here is quite acute. You obviously think that courts are sufficiently well placed to make these assessments, that they should be the ones making these assessments. I guess I'm wondering, do you see any downside to saying that ultimately it's courts that get to make this call? Do you think there's, you spent time in the Privy Council office. Do you think courts, understand what's at stake in a way that is sufficient to allow them to make those judgment calls about, whether disclosure of a cabinet confidence is justified in the circumstances?
Well, thank you, Vanessa. I absolutely think that the judges can perform that role, and they've been doing it under the common law and under statute law for all other types of government documents for decades without any problem. And it's important to bear in mind that, even if the trial judge might get it wrong, but then after there's a court of appeal and there's a Supreme Court. So I trust the judiciary to do that. But what your question is raising to me is, how should judge proceed to assess the competing aspects of the public interest and make a decision regarding disclosure? And this is something that I address in chapter 2 of the book when I talk about a rational or a balanced approach to cabinet immunity. And the key here is, when we talk about the public interest, we're talking really about two things. We're talking about the public interest in good government, which typically favors non-disclosure, and the public interest in the fair administration of justice, which will favor disclosure. So how do you balance both? And this is the key, and it's a struggle also under the common law to get that balance right. But there is no doubt in my mind that the person ultimately that must decide where the balance will fall, so to speak, is the judge, because determining the admissibility of evidence in litigation is a core judicial function. The executive can decide outside the context of litigation, but in the context of litigation, it's the judge who is in control of the proceedings, and it's the judge that must make the final determination. And also, the judge is independent and impartial, unlike the government when it is party to a litigation, for breach of contract or for a tort or negligence or breach of fiduciary duty. So you cannot have a party to a litigation decide what evidence will be admissible or not in that litigation.
Et merci, Yann. J'ai plusieurs excellentes questions ici que j'aimerais maintenant te demander. Je vais commencer avec une question. Ils sont tous en anglais. Je vais les lire en anglais. The first relates to the injury test that you propose, Yann. So the question is this: if we adopt an injury test, is a court well placed to assess the international and national implications of disclosure? The questioner here says this is not an area of expertise for courts. Would this require in-camera court proceedings?
It might, but the key point here is that, when the court is assessing the public interest in good government, the public interest in non-disclosure, the court is not doing that in the abstract. The government has a duty to file a certificate or an affidavit explaining to the court why the disclosure would be injurious to the public interest. And I do think that the judge should be deferential to the government with respect to the interest of good government. But on the other side, there's also the interest in the fair administration of justice. And there, the government does not have more expertise than the judge to make a call as to the relevancy of the evidence and the necessity that it be produced to ensure fair proceedings.
Great. Okay, so I'm going to take you now to the access to information context, which we touched on briefly, but interesting question here about access to information in an era of disinformation. So what do you make of the rise of access to information requests in the face of increased misinformation and disinformation efforts, which have undermined confidence in our public institutions? Should this current climate weigh in favor of greater transparency and more disclosure of cabinet documents?
Well, it's a very broad question, but I think our access to information regime must adapt. The regime that we have right now has been adopted in the 1980s, before the rise of the internet, before emails, before social media. So what we need essentially is to modernize that regime and to make it relevant to the current era. And that will require, I think, big changes inside the government as to the manner access requests will be dealt with in the future to remain, transparent, to protect what must be protected, but to do so efficiently.
Merci, Yann. D'accord, une autre question sur le sujet de donner la responsabilité à la Cour de décider si des documents devraient être divulgués pendant les procès. Et c'est une question qui vient de notre collègue Martha Jackman. Et puis elle dit, elle dit, mon impression, c'est que la jurisprudence de la Cour suprême du Canada en matière du secret ministériel et l'article 2B de la Charte n'inspire pas beaucoup de confiance que la révision judiciaire garantirait un niveau plus élevé de divulgation publique. Alors moi je m'inquiétais qu'on donne trop de rôle une rôle trop grande à la Cour. Martha demande maintenant, si on donne ce rôle à la Cour, est-ce qu'on peut être sûr que la Cour va divulguer des secrets dans les circonstances où c'est justifié, ou est-ce qu'on devrait être inquiet que la Cour va être too deferential to government?
Bien, je pense que ce qu'on remarque quand on regarde les décisions judiciaires qui sont rendues en vertu de la common law versus les décisions judiciaires qui sont rendues conformément à l'article 39 ou à l'article 69, c'est qu'il y a une grosse différence. Sous la common law, les juges, donc, ont la possibilité d'examiner les documents du cabinet et de sous-peser les aspects divergents de l'intérêt public. Et les cours au niveau provincial qui disposent de ce pouvoir-là l'utilisent. Et on voit dans plusieurs litiges, donc, des documents du cabinet ou des parties de documents du cabinet qui sont pertinents et qui sont divulgués à la suite d'une inspection par les juges. Maintenant, les juges, sous la common law, peuvent aussi prendre des mesures pour minimiser le risque de préjudice, soit en autorisant seulement la divulgation d'une partie d'un document ou en faisant en sorte que lorsque les documents sont introduits en preuve, ça se fait d'une manière privée et non pas publique. Donc, il y a différentes méthodes que les juges peuvent utiliser pour minimiser le préjudice. Mais les juges sont très actifs sous la common law et utilisent leur pouvoir pour justement maintenir cette balance entre la divulgation et la protection. Maintenant, à l'opposé, sous l'article 39, c'est un mur. C'est un mur. À moins qu'une partie puisse soumettre au juge des preuves extrinsèques d'abus de pouvoir, les documents vont rester confidentiels. Et en pratique, c'est très, très difficile pour une partie de démontrer que le gouvernement a mal appliqué l'article 39 ou a mal appliqué l'article 69, que ce soit une simple erreur ou que ce soit une erreur intentionnelle, sans avoir accès aux documents. Donc, ça prend un peu de chance. C'est arrivé dans le passé. Je parlais de l'arrêt Ettil. Dans l'arrêt Ettil, c'est parce que le commissaire à l'information a fait une enquête très, très poussée sur la question des documents du cabinet qu'on a été en mesure de démontrer à la Cour que la manière dont le gouvernement appliquait cette exception-là était déraisonnable. Mais en dehors de ces situations exceptionnelles-là, pour une personne normale qui poursuit le gouvernement, c'est pratiquement impossible de soumettre une preuve extrinsèque d'abus de pouvoir ou d'une mauvaise application de 39 ou 69. C'est pour ça que, selon moi, la meilleure façon de régler ce problème-là est de s'assurer que les articles sont appliqués de manière appropriée, c'est de laisser le soin au juge d'examiner les documents.
Great. Okay, so let's talk about another institutional question, which is, apart from the litigation context, how do you think cabinet confidences should be dealt with by Parliament and agents of Parliament, where arguably courts have no role?
So, as I was saying earlier, outside the context of judicial proceedings, it is the executive that will normally decide whether cabinet confidences should remain confidential or not. And, we've had debates between the executive and the House of Commons regarding access to cabinet confidences over the past decade. This is essentially, a political dispute between the executive branch and the legislative branch. In the end, the remedy for the House, if it's unable to get access to the information it requires to perform its constitutional function, is a vote of non-confidence. If, the government is in a minority. If the government is in a majority, there's not much the House can do. So that's the first part of the question. Then the second part, agents of Parliament. As I mentioned earlier, the Access to Information Commissioner does not have access to cabinet confidences. So the Access Commissioner can examine any government documents to make sure that the act is properly applied, except cabinet confidences. That's a problem. I think we're lacking meaningful oversight here because the Information Commissioner cannot properly perform a role. There's an exception in all that, and it's the Auditor General. The Auditor General was able to negotiate an agreement with the Mulroney government in the 1980s, under which it can access some cabinet documents, essentially documents that are factual in nature, in order to perform her role, so to audit public accounts. So there's an order in council defining the scope of what the Auditor General can see. And, of course, from time to time, there are disputes between the Auditor General and PCO or the Treasury Board as to whether the Auditor General can see a specific document. But overall, that framework works. It works because the two parties were able to reach a balance between what can be disclosed to enable the Auditor General to carry her function and what must remain confidential to protect the proper functioning of responsible government.
Thank you, Yann. D'accord, maintenant j'ai une question de notre collègue Marie-France Fortin qui demande si le maintien du gouvernement responsable sert de justification pour le secret ministériel, ne peut-elle pas aussi militer à l'encontre de la reconnaissance ou du moins la limitation du secret ministériel?
Oui, absolument. Donc, merci beaucoup, Marie-France. C'est un argument d'ailleurs que je fais dans le premier chapitre du livre, c'est-à-dire que si la raison d'être du secret ministériel, c'est de faire en sorte que le système de gouvernement responsable fonctionne de manière appropriée, le secret ministériel ne doit pas aller au-delà de cet objectif-là. Donc, quand je dis que l'immunité est trop large en ce moment, c'est essentiellement une reconnaissance du fait que l'article 39 va trop loin, va au-delà de ce qui est nécessaire pour assurer le bon fonctionnement du système de gouvernement responsable. Et donc, une partie de cette disposition-là, à mon avis, n'est pas justifiée. Celle qui excède ce qui est nécessaire pour assurer le bon fonctionnement du système de gouvernement responsable.
Now a question from our colleague Paul Daly, who says that the Federal Court of Appeal has suggested in recent decisions that a refusal to disclose confidential information can justify the drawing of a negative inference about the reasonableness of a decision challenged on judicial review. What do you think about this line of cases? And in particular, whether it can limit the overbreadth of privilege. And as I read this, as someone who is not who doesn't do well with oral, I do better when I'm reading something and not just hearing a complicated question asked. I'm happy to repeat any parts of that, Jan, but maybe you got it the first time through.
Yes, thank you, Paul. I think I understand the gist of the question. So in Babcock, the leading Supreme Court case on Section 39, the court said that, if the government claims cabinet secrecy by issuing a certificate, the judges, they can't examine the documents, but they might be able to draw an adverse inference against the government for claiming cabinet immunity. So I think the assumption here is that the cabinet immunity claim is improper, that the government is hiding information that could be relevant to the fair adjudication of the case. So I'm a bit uncomfortable with that because in the end, cabinet immunity is a public interest immunity. And unless proven otherwise, we must assume that the immunity is claimed in good faith and to foster the public interest. So it seems inconsistent with that view to draw an adverse inference from the fact that the government is trying to protect the public interest, unless there is evidence suggesting that the government is acting improperly or abusively. But in a case like that, I think the best course of action would be for the court to actually inspect the documents to make sure that the immunity has been properly claimed. So I understand why we have this rule of adverse inference right now, and short of allowing judges to inspect the document, it might be a reasonable fallback, but it's not the optimal solution in my view.
Okay, Jan, I have one more question for you and then we'll wrap up. And I think it's, in some ways the perfect wrap-up question because it connects our discussion today very much to current events. And that is the question of, how does all of this work in the context of a supply and confidence agreement, like the one that we've seen recently negotiated between the Liberals and the NDP. This is clearly not a coalition government. We're not talking about members of the NDP being part of cabinet. But, could we see, do these rules adjust a little bit or need to adjust in a context where the NDP have agreed to cooperate, strategically and around certain key policy areas?
Well, thank you for that question. Well, as you mentioned, there is no coalition between the Liberals and the NDP. So the NDP doesn't have a seat at the cabinet table. So in principle, the NDP won't have access to cabinet secrets or cabinet confidences. So in that sense, nothing will change with respect to cabinet secrecy. Now, what might change, of course, is if you have an agreement to collaborate with another political party, that will require a certain level of coordination. And, perhaps, behind closed doors in the House of Commons, members of both parties will share information, and perhaps the Liberals will share more information with the NDP than they would if there was no agreement between them. But with respect to the framework of cabinet secrecy, it won't change anything.
I see that you have managed to wrap up by stealthily including a reference to the title of your book, Behind Closed Doors. I think that's a great place to stop. Merci beaucoup, Jan, pour cette belle discussion. Behind Closed Doors is available now from UBC Press. And so, and I'll also say it's available at a very reasonable price point. So I encourage you to pick it up and read it. Merci beaucoup, Jan.
Merci infiniment, Vanessa. C'est un plaisir.